Hello everyone and good day from Montreal. Bonjour à toutes et à tous. Bienvenue. My name is Maria Manoli and I am the Executive Director of the Institute of Air and Space Law here at McGill, where I am also a doctoral candidate currently finishing my PhD. And today I will be moderating this webinar. I would like to warmly welcome all of you speakers and attendees to our new webinar series that will focus on the role of law in a rapidly evolving aviation industry. Today, we're launching the series with this first episode on a very topical theme, that is airline bankruptcy and aircraft lease restructurings and repossessions. Before we begin, I would like to thank the audience for your interest in joining this webinar. I have to say that we reached full registration capacity in just over a week. So thank you very much for that, and especially for being here with us on a Saturday morning or even a Saturday evening for some of you. Thank you also to our experts for offering us their time on a Saturday, and to Kiran Vazhapully, our LLM candidate here at the Institute of Air and Space Law, who has contributed to the organization of this event. I will now hand it over to Professor Jakhu, who will introduce our new webinar series and say a few words on our first episode. I am sure you all know Professor Jakhu, but for those of you who don't, Professor Jakhu is an associate professor here at the Institute of Air and Space Law and the acting director of the Institute. Professor Jakhu teaches and conducts research in international space law, law of space applications, law of space commercialization, space security, national regulation of space activities, and public international law. For over 2 decades, he has been providing consultation to several private and governmental entities, and he has been drafting national laws and regulations in various countries. Professor Jakhu is the project director of the Milamos project here at McGill, and in the past, he has served as the first director of the Master of Space Studies programs of the International Space University. Professor Jakhu, the floor is yours.
Thank you very much, Maria, for a kind introduction. Hello and greetings from beautiful Montreal here in Canada. On behalf of McGill University and of the Institute, it is with great pleasure that I welcome you all to a webinar on airline bankruptcy case study and aircraft lease restructuring and repossessions. This is the inaugural episode of the Institute series of webinars that will examine law in a rapidly evolving aviation industry. I will provide more information in this regard a little later. First, I would like to make a formal statement that recognizes the unique and enduring relationship that exists between indigenous peoples and their traditional territories in Canada. I quote, McGill University is located on land which has long served as a site of meeting and exchange amongst indigenous peoples, including Haudenosaunee and Anishinaabe nations. McGill honors, recognizes, and respects these nations as the traditional stewards of the lands and waters on which we meet today. This statement befits very well with the purpose of the webinar, which is a meeting of people from around the world. I believe some of the attendees might not be aware of the McGill Institute of Air and Space Law. So let me say a few words about our institute. Since its inception in 1951, the institute has been the world's leading academic institution in the fields of air and space law. The institute offers graduate level education and provides opportunities for advanced research at 4 levels: graduate certificate, Master of Laws, Doctor of Civil Law PhD degree, and postdoctoral fellowships. It has produced more than 1,200 graduates from more than 120 countries. In 1996, the Institute received from the International Civil Aviation Organization the prestigious Edward Warner Award, which is the highest distinction in the field of civil aviation. The Institute has a long and rich history dedicated to excellence in graduate legal education, public service, consultancy, and scholarship. As the domains of aviation space activities continue to grow and expand, the Institute looks forward to building on the efforts of its staff, alumni over the years to excel long into the future. Now, of the webinar. The idea of organizing this webinar originated a year ago. In the Economic Times of India of 24th October 2020, I read a fascinating story about the resurrection from bankruptcy of Jet Airways, which was one of the most successful airlines in India. It was reported that, I quote, tortuous negotiation, threats, claims, counterclaims led to a resolution, unquote. What was more fascinating to me was that one of our graduates, Mr. Gautam Acharya, played a significant role in this resurrection. I thought it would be great if Gautam could share his experience with our students. When I proposed this idea to Gautam, he agreed to explore this possibility. He will be formally introduced by Maria a little later, but I would like to say that Gautam, and we are very proud of him as our alumnus, is a well-recognized, highly experienced aviation professional in the Indian aviation and aircraft leasing field. He has witnessed 3 aviation downturn cycles in 2008, 2012, and 2019, and emerged successfully from all of them. Later I discussed the idea of a webinar with my esteemed colleagues, Dr. Donal Hanley. Donal, who is an experienced and knowledgeable professional, teaches at our faculty a course covering legal aspects of aircraft finance. Ensuing discussions among Gautam, Donal, Maria, and myself led to the Institute's decision to initiate a series of webinars that will examine law in a rapidly evolving aviation industry. As I mentioned earlier, this webinar is the inaugural episode of this series. Second and third episodes have already been planned for early November and early December this year. And we will provide more details about these 2 episodes later on. The rationale for this webinar is as follows. As we all know, COVID-19 pandemic has caused unprecedented negative effects on humanity. Undoubtedly, the worldwide aviation industry has been its major victim. In the evolving aviation world, numerous processes and practices have had to undergo a serious rethinking. Thus, the purpose of this webinar series is to highlight what some of those changes are, how they will impact us going forward. The webinar will start with the aircraft leasing world, which contributes the most basic yet fundamental aspects of the aviation industry. A final note I would like to make for those who may not be aware of the importance of today. Today is the 2nd of October, which marks the 152nd birth anniversary of Mahatma Gandhi. Einstein was deeply inspired by Gandhi's teaching, and so much so that he called him the most enlightened of all the politicians of his time. I personally too like two quotes from Mahatma Gandhi. One is that the future depends upon what you do today. I think that's quite relevant for this webinar. The second is very close to my heart or my thinking, I quote, "Non-violence is the greatest force at the disposal of mankind. It is mightier than the mightiest weapon of destruction devised by the ingenuity of mankind, of man." And I quote, "I leave the organization and detailed contents of to the moderator and our highly competent panelists. I wish you all a productive webinar and hope you will find this seminar enjoyable and fruitful. Thank you very much for your attention. Over to you, Maria.
Thank you very much, Professor Jakhu, and thank you also for reminding us the importance of Indigenous peoples and their lands, especially 2 days after the inaugural National Day for Truth and Reconciliation of Canada. I would now like to introduce our invited speakers, Gautam Acharya and Donal Hanley. Gautam Acharya, our first speaker, is the Vice President in Aircraft Leasing, Human Resources, Legal and Regulatory Affairs of Jet Airways in India. Gautam is an aviation expert, having specialized in commercial aviation for most of his adult life. He is qualified to practice law in India and the UK after having obtained a Master of Laws degree specialized in air and space laws from our institute in 2005. His work experience spans 3 continents, as he has worked in Canada, the UK, Sweden, Hong Kong, and India. For the last 13 years, he has been with Jet Airways in India, and he has managed multiple portfolios ranging from aircraft leasing and contracts to regulatory affairs to law. Over the last 2 years, he has worked closely with the court-appointed administrator, and he has been pivotal to help Jet Airways successfully emerge from a corporate insolvency resolution process. His assiduous efforts are now in the direction of getting Jet Airways off the ground. So thank you very much, Gautam, for being with us today. And our second speaker, Dr. Donal Hanley, is an adjunct professor here with us at the Institute of Air and Space Law at McGill. He is also a non-executive director of several aircraft leasing and trading companies and an instructor in aircraft leasing and finance with the International Air Transport Association and with others. He has previously been managing director of the Irish operations of a large commercial aircraft leasing company, and he has co-founded a commercial aircraft leasing company in Egypt. He is qualified as a lawyer in Ireland, England, and California, and his career spans Europe, the Middle East, Asia, and North America in both international law firms and aircraft leasing companies. He's a fellow at the Royal Aeronautical Society, and he has over 30 years of experience as an aircraft leasing and finance lawyer, and he has restructured leases and repossessed aircraft in many countries around the world during the course of his career as a practicing lawyer. His book on aircraft operating leasing is the reference work on the law of aircraft operating leasing. We are very thankful to have you both here today, and we look forward to your insights. Before I give the floor to our speakers, I would just like to mention that you can send us your questions via the chat throughout the webinar, and we will have a dedicated Q&A session at the end of this webinar, where the speakers will answer your questions. And please keep your cameras and microphones closed so that we can maintain a good internet connection. I would now like to invite our first speaker, Gautam, to launch his presentation. Gautam, the floor is yours.
Thank you so much, Maria. Welcome to all of you. Thank you, Dr. Jakhu, for your kind words and the introductory remarks. Donal, I'm honored and flattered to be sharing this space with you. Let me just start with a screen share. So good morning, good evening to all of you from different parts of the world. All of you know that the first episode of this webinar that the Institute has started is on an airline bankruptcy case study and aircraft restructurings, lease restructurings and repossessions. So for those of you who are not entirely conversant with India, just to put things in perspective, India is the 7th largest country, 8th largest if you can consider Antarctica. It's got a population of 1.2 billion, which probably has grown now to almost 1.3. So it's the 2nd largest population in the world after China. As per IATA forecasts, the Indian aviation market is supposed to grow to being the 3rd largest aviation market by 2024, overtaking the UK. But we don't know whether COVID or any further variants is likely to change that prediction. Coming to the aviation landscape in India, in 2019, and I take this back to that point in time, which is a pre-COVID point, India had a total of 18 scheduled carriers. Now you'll see over here, I have the number, 15 scheduled carriers with the numbers +2 and +1, which took the number to 18. 3 national carriers, which is Air India Express, and Alliance Air, and these 3 airlines are currently being spoken for by the Tata Group. And private carriers, which included Jet Airways and Jet Light, which unfortunately were grounded in April of 2019, and other private players. There is one all-cargo carrier, and I've not mentioned it over here, that's Blue Dart. And there are 2 other carriers, one helicopter carrier called Pavan Hans, which again I have not included, or the logo I have not included, and 2 very small carriers, Zoom and Air Odisha. At the bottom right-hand corner of the screen, you'll see a logo of Air Deccan. I just want to clarify for those of you who have keenly followed the Indian aviation story that this Air Deccan is actually called Deccan Air. It's an airline that started in 2017 and it grounded in 2019. It was a very small regional carrier based out of Ahmedabad, serving 4 destinations, and it had 2 Beech 1900D aircraft types. When you looked at these airlines operating in the Indian airspace, Indigo by far was the largest player with 48.2% market share, with the 2nd largest airline being SpiceJet at 15.6%. All the other carriers, Air India included, which is the national carrier, had much smaller numbers than Indigo, and the chart, the bar that you see on the right of the screen, because Jet Airways and Jet Light were grounded in April of 2019, their market share was 0.1%. At the time when Jet Airways was operational, this number was almost 16%. So Jet Airways was the 2nd largest carrier, but unfortunately the financial situation of the airline brought it to where it is. So given this landscape of where the Indian aviation market was in 2019, I'd like to take you back to how it all began in India in aviation. It all started in 1932 when Mr. J.R.D. Tata, after whom who's part of the Tata Group, who is now bidding for Air India, he flew a Pusmoth aircraft from Karachi, which was in undivided India, now in Pakistan, to Bombay. 14 years later, that is 1 year before our independence, Air India was established as a public limited company, and by 1948, the airline started international operations. Almost 40 years later, in 1990, the Indian government came out with a whole raft of economic reforms, which led in 1991 to airline deregulation. The permission by the Indian government to deregulate the airline sector spawned the growth of private airlines, and in 1992, Jet Airways was incorporated, and it commenced operations a year later in May 1993 with 4 leased aircraft, which we got from operating leased aircraft, which we got from a reputed lessor. By 1996, most of the private startup airlines had collapsed, either because they did not have the expertise or they did not have the proper management to run it. And the Indian aviation firmament was populated by Air India and its associated carriers, Jet Airways, Air Sahara. So these were the only carriers that were flying around in the Indian skies 1996 onwards till 2003. 2003 marked a watershed moment for Indian aviation when there was a second wave of airlines that started up, and that's when the low-cost carriers started making their entry. So Air Deccan, which some of you may have heard of, started out in 2003. That was followed by Indigo, SpiceJet, Go Air, and the others that I've spoken of in the earlier slides. In 2004, the private airlines were finally allowed by the Indian government to fly international routes. Up until this time, aviation was heavily controlled by the Indian government, and airlines were only permitted to fly domestically. So Jet Airways launched flights in 2004 to Colombo and Kathmandu. In 2005, Jet Airways went public, and its IPO, or initial public offering, was oversubscribed 16 times, and the company was valued at $2.3 billion, a staggering sum. When Jet Airways was flush with funds, what Jet Airways went out and did was it placed a very large, or a very significant for an Indian airline at that point in time, wide-body aircraft order for 10 Boeing 777-300ER aircraft and 10 Airbus A330-200 aircraft with options on those. These aircraft were to start delivering to Jet Airways in 2007. 2 years later, in 2007, Air Sahara, which was one of the private carriers that had started out after the liberalization in 1993, Jet Airways went and acquired Air Sahara, which we came to christen and the flying public now knows as Jet Light. Now, for those of you who are slightly conversant with Greek mythology, there were two crises that struck the Indian aviation industry, and I call this the first order and the second order in the Indian aviation story. The first order, or the first crisis, was the global financial crisis that struck in 2008-2009, as a result of which there was a significant shrinking of the markets. One of the casualties of this crisis, number one, was Paramount Airways, which was one of the carriers that had started out between 2003 and 2006 to collapse in 2010. 2 years later, the second crisis struck, which led to the unfortunate demise of Kingfisher Airlines. Now, we've always realized, and I'm sure a lot of you have heard this story about how to survive in a forest if a bear attacks you and you're a bunch of people. You need not be the fastest runner. All you need to do is you need to be you need to be at least the second slowest runner, because by the time the bear gets to the slowest runner and captures him, you're safe. So in 2010 and in 2012, the slowest person, or the slowest airline, was Kingfisher and Paramount, and they unfortunately were the casualties. Jet Airways managed to avert these crises by doing a couple of things. In 2008-09, the airline started operating like a quasi-aircraft leasing company, where the almost 20 wide-bodied aircraft that we had was subleased to multiple carriers. We started out subleasing aircraft to Turkish Airways, Gulf Air, Oman Air, subsequently to Thai Airways, and finally to Etihad Airways and Air Serbia. As far as the next crisis was concerned, which struck us in 2012, Etihad Airways came to our rescue, and they did so by acquiring a 24% equity stake in Jet Airways, and that fuel injection in Jet, the financial injection provided by Etihad, helped Jet keep itself afloat. What did we learn from these crises? Crisis 1 and Crisis 2 enhanced our vocabulary by giving us terms like Christmas trees, robbery lists, which we hadn't heard of. What we had learned from lessors who were also leasing aircraft to other airlines was that aircraft had been parked, and because they couldn't pay for spare parts, or because they couldn't pay to maintain the aircraft, they would make Christmas trees off these grounded aircraft, pick parts out of them, cannibalize parts, put it on other aircraft to make them airworthy and keep them flying. I'm sure when Donal will be talking to you about his experiences, he'll tell you more about this. There were lessors that had robbery lists of parts where their aircraft had been cannibalized, and those parts had been fitted on other aircraft. So even if a lessor was to repossess its aircraft, they'd probably get an aircraft with a lot of parts picked out of it and planted on another aircraft that was flying. One important thing that we learned at Jet Airways was lessors telling us to talk to them. Lessors would reach out saying, listen guys, we know you're in financial distress. We know you're going through problems. Talk to me. I'm just as interested in your survival. I'm just as interested in you keeping the aircraft. But if you have an open and frank discussion with me, I'll be able to do things to ensure that you keep afloat and you don't go, the situation does not deteriorate beyond anyone's imagination. This led to Jet Airways engaging in rent deferrals with aircraft leasing companies, restructuring leases. So basically telling lessors that, look, I can't pay you the $100 I'm supposed to pay you today. Let me pay you 80, and the balance 20 will be paid to you when the financial condition improves, and we are able to pay you the complete amount. Some lessors were willing to do early terminations on aircraft. They were willing to take aircraft back with the understanding that there would be replacement aircraft orders. So they take away an old aircraft with the understanding that in a couple of years, we'd place an order, or we'd lease newer, more modern aircraft from them. The Cape Town Convention was something that was also of significance here. Now, India deposited its instrument of accession on the 31st of March 2008 and subsequently ratified it, with the Cape Town Convention coming into force on the 1st of July 2008. To make the Cape Town Convention more effective, the Indian regulator, which is essentially the DGCA or the CAA as other parts of the world would refer to an aviation regulator, they came to recognize India's accession to the Cape Town Convention. Up until that time, India had not had any lessor, including Jet Airways, offer it an IDERA, or an irrevocable deregistration and an export request authorization. All that the Indian regulator was used to seeing was a DPOA, or a deregistration power of attorney. Very often, in their enthusiasm to issue both documents, there would be a mismatch. And we'd have lessors having different names on an IDERA and a DPOA. And when the regulator, the DGCA, received an IDERA or a DPOA seeking to deregister and repossess an aircraft, they were a little confused as to who had the authority to deregister and take the aircraft back. The learnings from Kingfisher and Paramount, which I think got crystallized also now with Jet's grounding a couple of years ago, was to ensure that we make the Cape Town Convention more robust and effective. There have been steps to codify the Cape Town Convention into Indian law, and I'll touch upon it in a few moments. We learned from lessors that lessors had consciously taken a conscious and deliberate decision not to lease aircraft to India. It was not airline specific, it was more a jurisdictional specific blacklist, if you'd like to call it that, where lessors were a little wary about leasing aircraft into India. India's reputation as an aircraft leasing market took a bit of a dent, but I think it corrected itself with time. Lessors at that point in time would expect security deposits to be enhanced. Lessors would also consider shrinking their transaction book size, saying that, look, we don't want to lease 5 aircraft into India. We'd probably do it with 1 or 2, see how the markets go, see if there's a restoration of order in India, and then we'd probably come back to how things were before those insolvencies or those groundings took place. Now, what was Jet Airways like before it was grounded? Jet Airways was the second largest airline in India. And at the time, April 2019, before it grounded, it had a total fleet of 123 aircraft, which was a mix of Airbus, Boeing, and turboprop ATRs. Our wide bodies included the A330-200s and 330-300s. And the wide body offering on the Boeing was the 777-300ER. The tabulation that you see on your screens is pretty self-explanatory as to what we had, so I won't waste too much time on this. But suffice to say that we had a total of 123 aircraft in our fleet. What was our order book like? our order book had 225 Boeing 737 MAX aircraft. Out of these 225 aircraft, we had 100 aircraft which we had sold and leased back, but these aircraft were still to be delivered to us. This 225 excluded other committed leases that we had from lessors, which constituted aircraft from their order book. We had 10 Boeing 787s and 5 Airbus A330s also, which were likely to come to us. But this was going to take place all the way up to 2027, 2028. What was the scale of operations of Jet Airways prior to grounding? As I mentioned to you, we were the second largest airline in India. We had a fleet of 123 aircraft with a 16% market share. If you've got a flavor of what Jet Airways was like, I will move to my next slide that talks of what happened in 2018 that led to the grounding of Jet Airways. It is no secret that the airline was grounded because of stretched financial conditions. What had happened was, because of the large number of low-cost carriers in India, they had the power to price themselves much cheaper than a full-service carrier or an airline of the stature of Jet Airways. And that led to predatory pricing in the market, as a result of which we were not able to break even on the fares that we were offering, even though our loads were healthy. Liquidity was drying up and our costs were going up. And banks at that stage had kind of turned the tap off on us, saying that they were not prepared to fund the airline any further. The Boeing MAX aircraft also had its issues with the global grounding of the MAX, but I wouldn't say that had a very, very large contributing factor to the grounding of the airline. As a consequence of this financial ill health that the airline found itself in, on the 18th of April 2019, there was a complete grounding of the airline. I use the word complete grounding or full grounding because on the 12th of April 2019, a week prior, we had to cease all our international operations. Between the time when the airline's financial health deteriorated and 20th of June 2019, and I use the date 20th of June 2019 because that's when the insolvency process of Jet started, so 2 months after the actual complete grounding took place. Jet Airways did a lot of things to try and get itself back on its feet, get itself up in the air. One was its engagement with its equity partner Etihad Airways. The second was talking to interested investors. We had spoken to private equity houses, we had spoken to other airlines, we had spoken to banks, but unfortunately nothing came to be. Then the State Bank of India, which is India's largest public bank, worked with Jet Airways, and they came up with something called a bank-led provisional resolution plan. There were 8 to 9 iterations of that document, where the banks were trying to help restructure the airline so that the airline could avert the grounding that it eventually had. Now, the entire bank-led provisional resolution plan was based on a 12th February 2018 circular issued by the Indian Central Bank, the RBI, which circular essentially laid out a policy or the framework for resolution of stressed assets. Unfortunately, in March of 2019, while we were going through the 8th and 9th iterations of the bank-led resolution plan, the Delhi High Court struck that RBI circular down as being ultra vires, and therefore we could not proceed with the bank trying to bail the airline out of the problem it found itself in. Through this period, we had a raft of grounding notices. We tried engaging with aircraft lessors, but their patience was also wearing thin. We had aircraft, given our fleet being 123 aircraft, we had aircraft parked all over the country. Airports were running out of space, and we really didn't know what to do because we didn't have permission to fly them because the lessors had sought a grounding because we were not able to pay them. And on 20th of June 2019, the State Bank of India, because we were unable to repay the loans that we were supposed to, initiated a corporate insolvency resolution process, the Indian equivalent of, say, a Chapter 11, under the Indian Insolvency and Bankruptcy Code. It must be noted that the Indian Insolvency and Bankruptcy Code is a relatively new legislation which came about in 2016. It had not been tested on any any other airline before, not Kingfisher, not Paramount, and we seem to be the guinea pigs for it. What did the Insolvency and Bankruptcy Code seek to do when Jet Airways was admitted into its insolvency process? It first went and appointed an administrator, a person called a resolution professional under Indian law, to manage the affairs of the company. By the time the resolution professional, or RP as we abbreviated it, came into the company, all the senior management, most of the senior management had left. You had some staff, when I say some, you had 9,000 staff who were still on the rolls of the company, hoping for a miracle for the airline to start. The company was controlled, while the company was controlled by the resolution professional, a committee of creditors was constituted under the bankruptcy code, which committee essentially comprised the financial creditors, the banks. The RP then constituted what is called an asset preservation team, and that this was a first in the history of the Insolvency and Bankruptcy Code, where he identified people who were left in the company who would be able to help him navigate the aviation world or the turbulent skies, because he was not an aviation person. He was from the accounting world. I was a member of this asset preservation team, along with about 200 of my colleagues from different departments, to support the resolution professional in managing the whole show. What were the jobs that the resolution professional needed to do? The first, of course, was inviting, scrutinizing, and admitting claims. The second was preservation of assets, largely aircraft, engines, spares, and other inventory. And the third, of course, was to parallelly manage or cooperate with the insolvency process that had commenced in Holland and the UK. And the last, of course, was to ensure that the airline and its assets were packaged and we could offer it to interested parties to bid for it, so that a revival of the enterprise could take place. Now, you might wonder why these three items in the middle are in color, and each of them, of course, I have a little more to talk about, so I'll take you to those slides and spend a few moments on each of those. Insofar as the claims that the airline received a staggering 20,982 claims, totaling $5.8 billion. We had claims from financial creditors, operational creditors, employees and workmen, other creditors, and of course the Dutch administrator, which formed part of the Dutch insolvency. I'll talk to you about the financial creditors and the operational creditors in a moment, but talking about the employee-related claims, as you can see from this chart, from this tabulation, there were about 14,000 employee-related claims, totaling $150 million. These were unpaid dues to employees in terms of salary that had not been paid to them because of the poor health of the airline, gratuity and leave encashment payments, and other payments that employees were due for when they would normally terminate. In terms of financial creditor claims and operational creditor claims, we'll move to that right away. So we had a total of 38 financial.
Sorry, Gautam, if you don't mind my interrupting, just one question that intrigues me here is, correct me if I'm wrong, but it seems to me that one of the key problems in avoiding insolvency was the overturning of the RBI circular. And that's what precipitated the proximate cause of precipitating the insolvency proceedings here. Who brought that claim? What was it? One of the creditors here, or what was the motivation of somebody in seeking an order to set aside the RBI circular?
So the RBI circular, Donal, was set aside by the court, by the Delhi High Court, but by the Supreme Court. But the claim that was brought against Jet Airways to admit it into insolvency was the State Bank of India, the bank that was trying to work with the other consortium of banks to try and revive Jet Airways under the various bank resolution plans.
Okay, thank you.
Thank you, Donal. So as you can see from these tabulations over here, we had a total of 38 financial creditor claims totaling $1.5 billion, of which only $994 million were admitted by the resolution professional. Turning our attention to the operational creditor claims, we had, just bear with me a moment, So as you can see, we had 75 aircraft lessor claims for $1.9 billion. Only $305 million of these were admitted. And you may ask why. So what happened is when all the aircraft lessors repossessed their aircraft, a lot of the claims that were filed was for lease rental amounts that would accrue to them for the remaining period of the aircraft lease term, assuming that the aircraft had been with us for the entire duration. However, in assessing these claims and admitting it, only the lease payments that were due up until the time the repossession took place is what were admitted. It is also significant to note that there were 5,174 ticket claims that passengers had claimed. They had claimed a total of $416 million, of which only $280 million were admitted. Now, I think I've spoken a lot and inundated you with too much of text, so let me make it a little easy on your eyes. Here are some pictures I'm going to show you and walk you through how we went about preserving our assets to ensure that the assets were preserved and packaged in a way that an interested party would find value in the airline and bid for it. So this is how we went about preserving our engines. This is how we went about preserving our engines and transporting them. So one of the things that happened at that time was, because our aircraft were parked across the country, some aircraft had been repossessed, the airframes and their attendant engines were not in the same place. So we needed to transport engines from where they were to where the airframe was. So this is an example of how the engine was packed or preserved and then transported. And this particular engine is a Boeing 777-300ER engine, which is a GE90-115B engine. And you can see that over here, GE90-115B in the bottom left-hand corner. Here's how it's being transported. So this was an exercise in itself where we'd not done something like this, and we needed to send it by surface. We couldn't airlift it because we didn't have the money for it. So this engine has traveled almost 2,000 miles by road, because that was the only way this engine could move from a city in the south of India to a city in the north of India. Those of you who know these cities, this engine went from Madras to Delhi. We needed to carry out cabin preservation. So aircraft that were parked obviously couldn't be left as they were. India has a harsh climate. We have a monsoon, we have a winter, not as bad as Canada. Very harsh summers, high humidity levels during the monsoons. So we needed to preserve the cabins by putting large plastic sheets over them. So this should give you an idea of the extent of the exercise. And we did this for 12 of the aircraft that were still left with us, because the remaining 110 had been repossessed. One aircraft was with Air Serbia on sublease, and I'll talk about that in a moment. So as you can see, this is how the cabin was preserved. Okay, so now this is an interesting story. On the 12th of April, I mentioned to you that our international operations were stopped. And one of the things that had happened around that time was our Boeing 777 aircraft that had gone to Holland on a scheduled commercial flight had been, well, hijacked is not the right word. One of the creditors in Holland got a restraining order and arrested the aircraft in Holland. And this aircraft was parked over there. Unfortunately, because the aircraft was not within our control, we could not carry out the extent of preservation activities that we did in India, but we got the support of KLM Engineering to preserve it. For those of you who are curious to know what lies underneath the seats that you sit on, the picture to your right indicates what the belly of the aircraft is like. Strangely, I mean, the average height of a male in Holland is 1.82 meters. And I'm slightly taller than that, and you can see how high the belly of the aircraft that was arrested in Hong Kong is. Looks in good shape. I went to inspect it along with the RP, and we were quite pleased at what we saw. So those of you who've flown through Amsterdam in the recent past, you may have seen this tucked away in some remote corner of the Schiphol airport. Now, coming to something a little legal, what were the various insolvency-driven regulatory changes that India put in place around the time of an airline insolvency. Some of this predated Jet's insolvency, and some of these happened after Jet was grounded. The first was the DGCA, or the Indian Aviation Regulator, requiring no binding certificates to be issued to them. No binding certificate essentially confirms to the DGCA that no term of an aircraft lease agreement makes them a party, and the aircraft lease agreement is essentially something between the lessor and the lessee. As if the Indian DGCA was prescient and thought or knew that the Jet grounding was to take place, on the 6th of November 2018, the government, the DGCA, came out with an aeronautical information circular, which basically set down a standard operating procedure for implementing Rule 32A relating to the export of aircraft. So it's as if they knew that something like this, the Jet story was to happen, and they needed to kind of enumerate how aircraft needed to be exported out of the country under the Cape Town Convention, because obviously lessors would come with the IDERA seeking to repossess and fly their aircraft out. Shortly after Jet Airways was grounded, on the 18th of April 2019, the Ministry of Finance came out with a circular on the 18th of April, where earlier airlines usually took permission to fly the aircraft out of the country and then brought it back for tax reasons. This circular that the ministry issued allowed airlines not to have to do this, and the aircraft could go within the country from one airline operator to the other. I understand this has now been codified. I haven't seen it at work simply because we've been at an airline where we've not taken aircraft from another Indian operator. The reason why the Indian government came out with this was because a lot of the aircraft lessors who sought to repossess their aircraft from Jet Airways found easy homes for them with other Indian carriers who sought to fill the void that Jet's grounding led to. So other Indian carriers stepped in to launch flights to carry the passengers that would otherwise have flown on Jet aircraft. And since they didn't have the aircraft for it, aircraft lessors immediately took these Jet aircraft on lease themselves and started operating them. The last, of course, in terms of an insolvency-driven regulatory change, was to do with IDERAs, DPOAs, and CDDAs. We've spoken about IDERAs and DPOAs before, but another thing that developed was the CDDA, a Certified Designee Deed of Appointment. And I must confess, I only have theoretical knowledge of this. I have not seen this at work, because the CDDA is essentially a document that the IDERA holder, which is the lessor in most cases, issues in favor of the security trustee, and it's filed with the DGCA to let the DGCA know who they are to expect when an aircraft needs to be repossessed. And I'm sure when Donal starts speaking, Donal will be able to throw more light on this. So onto the resolution process of Jet Airways. The resolution process of Jet Airways involved 4 rounds of bids. The first 3 rounds were unsuccessful, obviously, which led to a 4th. And in the 4th round, we had a successful resolution applicant who submitted a bid, which was approved by the Committee of Creditors and the local court that was administering this whole process. As a result of which, the company now is in a state where the successful resolution applicant, the Jalan Calrock Consortium, have put in a successful bid to acquire the airline. They have a couple of conditions precedent that they need to fulfill. Once they do that, the company is handed over to them in its entirety, and they will then work to getting the airline back in the skies. When we get to the Q&A sessions, if there's any more information or anything else you'd like to know about this, I'd be happy to answer them. And this last slide of mine, now, those of you who can see me on the screen, this is what I looked like before the insolvency started, and this is what I look like now that the insolvency has come to a close. So this is the effect an insolvency process has on an individual. Thank you very much. Maria, over to you.
Thank you very much, Gautam, for this presentation. As I mentioned earlier, we will take the questions at the end, so we can now move on to our second expert, Donal Hanley. So again, thank you very much, Gautam. This was very, very insightful. Donal, if you have any comments on Gautam's presentation, please go ahead, or if you want to start with your own presentation, please go ahead as well. Thank you.
Thank you very much, Maria. And thank you, Professor Jakhu, for your introduction at the start. And Gautam, thank you very much for that fascinating presentation. Parts of it, the only time I dealt directly with Jet Airways, as you recall, was when we were putting a deal together in happier times when Jet Airways was, as you pointed out, the second largest airline in India, and I look forward to seeing its recovery in the market. So maybe from time to time during my presentation, I may refer back to some of the points which you raised, but which certainly your advice and perspective I very much endorse from my own experience. So moving to my own presentation, I'm going to talk in probably more general terms based off of the specific experience that Gautam has mentioned to you. But I start off with the same point with which he started off, which is for an airline, the importance of the airline speaking to its lessor when it, even before it gets into financial difficulty, when it anticipates that it will get into financial difficulty. And this is where the quality of the relationship with the lessor matters. And I'd be interested to hear from Gautam when dealing with different lessors, to what extent this made a big difference to them. This is a concern for airlines, as leasing now comprises over 50%, I think it's about 55% of the commercial aircraft fleet in the world. So more than 1 and 2 aircraft are leased from a lessor. Many lessors now make more money from trading aircraft to other lessors with the benefit of the lease attached than they do from the lease rentals themselves. What this means in practical terms for an airline is that whereas when I started in this industry 30 years ago, an airline might expect to keep the same lessor throughout the term of its 10-year, 12-year lease or whatever. Now an airline may expect to have maybe 3 or 4 different lessors during the term of the lease, as each lessor in turn decides that it is able to sell the aircraft subject to the lease at a profit to another lessor. This makes it difficult for the airline to maintain, or can make it difficult for an airline to maintain a good relationship with a lessor, which it may need to rely on when the airline gets into financial difficulty. In particular, what I'm thinking of here is where the lessor is essentially a managed fund. And so Gautam, I don't know if you have any direct experience of this. If you do, I'd be grateful to hear from you on it. What is interesting for me is that an airline can and should go and speak to its banks, regularly, even in good times, to keep the relationship fresh. Certainly in bad times, the airline needs to do that also with its lessors. But with if your lessor is a managed fund, you will be dealing with the manager, and the manager will be subject to a duty of care to the investors in the managed fund, which is to treat the aircraft with the same care that it would treat its own aircraft. Now, as Gautam pointed out, when the airline goes to its lessor, let's assume it's a real lessor, not just a manager, that lessor, amongst other things, will be concerned for the survival of the airline and for the hope in the future of putting future aircraft into that airline. In other words, preserving future business. But as a practical matter, if you're dealing with simply a manager who is an experienced leasing company but managing the aircraft on behalf of this investment fund, there is no future business. So they cannot really apply that test. My concern is in that case, where the airline is dealing with what is essentially a managed fund, the manager will probably have to advise if you like, a stricter approach, because there's no hope of future business. The investors in the fund don't plan putting further money into this investment. So I just mentioned that because it is more and more likely that even if on day one you are not dealing with such a lessor, the chances are that during the term of the lease, you may well be dealing with such a lessor. Speaking from my own lessor experience, I can tell you that lessors take very seriously and show a lot of respect for airlines when they do proactively say, look, we think we're going to have difficulty meeting our lease obligations this year, later this year, or next year. The worst thing that an airline can do is to go silent. When an airline gets into difficulty and doesn't pay rent on time, the lessor doesn't really worry for the first day or two, but it will then begin to worry. It won't necessarily panic immediately because the lease rent hasn't come in after a week, but certainly there will be great concern. If that continues, and if the lessors the airline's management don't make themselves available to speak to the lessor, certainly by the time a second month's rent has not been paid, the lessor will be speaking to other lessors in the market and finding out what's going on with the airline, and will probably be beginning to incur, or certainly considering incurring, outside legal expenses with a view to possible repossession of the aircraft. Gautam mentioned the precautionary arrest. I presume, Gautam, it was an ex parte arrest in the Netherlands. You weren't given notice beforehand. Yeah. So if you are not speaking to your lessor because you don't know what to tell your lessor, you're thinking, we don't know what to tell them, we just don't have the money. If you don't take their call, the lessor is probably beginning to phone lawyers to find out how they can arrest your aircraft. So if you want to avoid that, I really would advise you not to go down the route of silence, but to go down the route of proactive communication with your lessor. If the airline has decided that it really doesn't want the lease or cannot afford the lease, there has been some discussion, particularly in the context of COVID, but it applies to actually, certainly in the context of COVID, it can apply to other major market disruption as well. Whether the airline could argue that the lease has been frustrated or whether they are relieved of their obligations relying on force majeure. It's possible that such a case could be argued. Certainly in Jet Airways' case, that's not the case. This was a different background, as Gautam has very well explained. But most airlines faced major difficulty during last year and even into this year. Two cases to which I would draw your attention are ACG versus Olympic Airways, an English case. I have to disclose that at the time of this case, I was an employee of the parent company of the ACG entity, which was the plaintiff in that case. And Iris Helicopter, also an English case. With ACG versus Olympic, Olympic Airways inspected an aircraft which they were taking as a second-hand aircraft from ACG, and it was being redelivered from a previous operator. During the inspection of the aircraft, Olympic pointed out various things they weren't happy with, and they were all fixed to Olympic satisfaction. Olympic then accepted delivery of the aircraft, and within a few days, crucially, before they put the aircraft into legal service, they discovered a defect with the aircraft which led to the certificate of airworthiness being withdrawn by the Greek Aviation Authority where the aircraft was registered. Olympic Airways then basically argued that they should be released from the terms of the lease, arguing, actually in their case, arguing that there was complete failure of consideration. They said they had got no benefit out of the lease because the aircraft could not be put into service even for one day. Their argument went beyond that and said that because there was total failure of consideration, they were not bound by any of the provisions of the contract, including that provision of the contract which said that once they had accepted the aircraft and signed the certificate of acceptance, they had conclusively accepted delivery of the aircraft, and all risk of the aircraft, operational risk of the aircraft, had passed to them. The High Court in England rejected that argument on the part of, actually it was the liquidator of Olympic Airways, and on the grounds that it was a strange decision, on the grounds that Olympic Airways were stopped from alleging this at this point, because ACG had relied on their acceptance of the aircraft. It doesn't really make sense to me from a contractual point of view. The liquidator appealed that judgment to the Court of Appeal, and there the English Court of Appeal held that they were simply going to enforce the lease the way it was written. All risk passed at delivery in accordance with the lease. Therefore, absent fraud, if any problem was discovered with the aircraft after the point of delivery, that was entirely at Olympic's risk. Interestingly, the English Unfair Contract Terms Act, which could possibly set aside such a strenuous provision in a lease contract, does not apply to cross-border contracts. So it would be interesting to see if that case were ever to arise again with a domestic English lessor and a domestic English airline, if in fact these stringent provisions on delivery were to be upheld. The other case, which is from this year, from August, in fact, is Iris Helicopter. That's an interesting case where this is the lease of a helicopter to an Italian operator of helicopters. And the helicopter was delivered outside of Italy by the lessor in accordance with the lease contract, which said that the delivery location would be outside Italy. The aircraft was seized in Italian customs because import taxes had not been paid for the aircraft. The operator then argued that the contract was frustrated because they couldn't operate the aircraft at all. It was seized in customs. And the judge, relying on the ACG Olympic case, said that no, this was a very clear case where the terms of the lease were clear. Iris Helicopter had accepted delivery of the aircraft. All risk and obligations in respect of the aircraft had passed to Iris Helicopter, and indeed, under the terms of the lease, the payment of any import taxes was the obligation of the operator, the lessee. So I'm a little bit surprised, frankly, that that case even went to court. So I don't think an airline which does not want or can't continue with the lease is going to have an easy time itself going down a legal road to try and get out of the lease. So what else can they do? Well, as Gautam said, as I said, they can communicate with the lessor. They can seek to return the aircraft early to the lessor. In 2020, 2021, this was an even more difficult task than usual because from the lessor's perspective, the lessor had no alternative market to place the aircraft into. So that changed the dynamic somewhat. Certainly, we saw where airlines, and I've seen this even before COVID, with airlines proactively coming to the lessor and asking for a rent deferral. That's saying, look, we have a temporary liquidity crunch coming up. We would seek maybe 3 months relief from payment of rent in the hope that in 3 months' time, we can get up to speed again over a 3-month period so that, you know, it will only be a cash flow impact on the lessor. Within 6 months, you shall be back whole where you're meant to be. We are respecting the economics of the transaction. Certainly that will get a serious consideration from the lessor, who will appreciate that the airline was trying to respect the economics of the transaction and is explaining their problem. They would need to show the lessor, of course, what is their plan for being able to pay when they're proposing to get current on the rent again. And so they would need to share their business model. What happened, maybe that's not going to be enough for an airline. What they may need to ask for is an actual rent holiday, forgiveness of rent, to say, we don't just want to defer our rent over the next few months, we need you to not charge us rent at all. Or as a fallback, maybe they will say, we need a serious rent reduction. Of course, all these things are commercially negotiable. So, you know, the contract is still the legally binding contract until the parties agree to amend it. But this would be the sort of hierarchy of preference, Gautam, correct me if I'm wrong, which an airline might typically go through. As I said, before we get to any crunch proceedings, this is trying to head off disaster before it hits.
Donald, I just want to come in here
Sure.
Speaking from personal experience, so when we did go to the lessors and sought a rent holiday or a rent reduction, very often the answer we would get from lessors, and I don't blame them for this, is that, look, what you're seeking from me obviously is understandable under the circumstances, but when the airline starts posting profits, I don't come to you and ask for an increase in the lease rent, or you don't come to me saying, I'm making a profit, so will you please take a little more rent from me? So back to you.
And that's true. Oh, that's in fact, I've made that point myself on occasion to airlines. But what the lessor needs to be careful of saying now in that situation is, what's the lessor's alternative here? If the lessor doesn't take the aircraft, if the lessor doesn't agree to some kind of accommodation for the airline, and I talk now not in the specific situation of Jet Airways, but generally for airlines at the moment, which are still recovering from COVID, there really is no alternative market yet. Certainly not for wide bodies. Some markets have grown very powerfully again. I understand that the Indian market domestically is strong again, the Chinese domestic market is strong, and the US market domestically is strong. These are largely narrow body aircraft. But during the height of the COVID crisis, a lot of lessors agreed basically to a rent holiday, but on the basis that if the airline were to operate the aircraft, then they would pay on an hourly basis, what is called power by the hour. The benefit for the lessor there is, at least that means that if you simply say no to the airline and say, you know, I don't come to you seeking a greater share of your profits in good times, so why should I help you in bad times? In this situation, 2020, early 2021, with no alternative market, if they don't help their airline customer, the airline could well collapse. If the airline collapses, then the lessor will have to take possession of the aircraft. And this is the bottom line on this slide here. Now, not only is the lessor not getting any rent at all for the aircraft, the lessor has to take on the risk and the expense of storing and maintaining and insuring the aircraft, which are not small expenses. So from the lessor's point of view, a rent reduction, or at least a rent power by the hour, is preferable to having a collapsed lessee with no other lessee to take the aircraft on, because at least the airline will store and maintain and insure the aircraft on behalf of the lessor. Other relief which the airlines can seek is, some of you who are already in the industry will know this, but in addition to paying rent, an airline will typically pay a security deposit and maintenance reserves. Maintenance reserves are very expensive for aircraft. They can amount to maybe $2 million per engine on an A320 or a Boeing 737. And so rather than take the credit risk of the airline, which is good for airlines which don't enjoy a good credit rating, the lessor will collect on a monthly basis maintenance reserves from the airline sufficient to pay the anticipated scheduled maintenance on the aircraft. If the airline performs that maintenance in due course, that money is returned to the lessor, to the airline. If the airline collapses in the meantime without performing the maintenance, and now the lessor must take the aircraft back, the lessor must pay this for this maintenance. Again, it could be millions of dollars. And so that's why they hold on to those reserves. But that isn't actual cash of the lessor, so to speak. Sooner or later, it's supposed to go back to the airline in principle. So airlines have been saying, well, look, at least if we can pay you rent, will you at least help our cash flow by not making us pay these maintenance reserves? We know that our performance risk is higher at the moment due to our credit challenge, but if you could at least help us on this, that will help our cash flow. A lessor really should be agreeable to some kind of solution here, even if the lessor can't agree to that. What it could do is agree to accept a letter of credit, a standby letter of credit instead. A standby letter of credit is produced by the airline, whereby a bank issues the letter of credit in favor of the lessor. So there's a one-time fee that the airline has to pay, but at least the lessor, it doesn't impact the cash flow of the airline, and the lessor still has security in case the airline goes bankrupt without performing maintenance of the aircraft. By the way, lessors do not pay interest on maintenance reserves. And so with a standby letter of credit, even if the airline's credit is poor, they can get a secured standby letter of credit. In other words, they can grant security over certain cash that they hold, maybe the cash they would have paid to the lessor. They can pay it into the account of the bank which is issuing the letter of credit and grant the bank security over it. The benefit for the airline in doing that, frankly, is that the bank will pay interest to the airline. And at least in that respect, although the airline has to pay to obtain the letter of credit, it can at least enjoy interest on the money. It would never enjoy interest on the maintenance reserves while they're being held by the lessor. Another possibility is a buyout of the aircraft. This suggests that the airline is in a position to do that. But in the worst case, they could say to the lessor, especially for older aircraft, they may be able to say to the lessor, look, this aircraft is already 20 years old or whatever. It's really not worth very much. You're going to be breaking it up for its parts. Why don't we just buy it from you to get out of our lease now? Again, it will be very much dependent on what the other alternatives available to the airline are, other alternatives available to the lessor are, and the overall general circumstances. But these are all of the areas in which I'd invite an airline to discuss, brainstorm, if you like, with the lessor to find a mutually acceptable solution, if at all possible. And real lessors, as I said, not just the managed lessors, but actual lessors are interested in good relationships with airlines. And they're also aware that they themselves have reputations which are shared amongst airlines. So they'll be motivated to be helpful insofar as they can be. But of course, they have their own expectations. They themselves may be leveraged and have their own creditors who have expectations, and they will, of course, have their own equity investors. That brings me back to the discussions which Gautam mentioned that Jet Airways had with its financiers, lessors, and investors. The approach taken by each is somewhat different. Banks, of course, being regulated entities, have limits on what they're able to agree to. Leasing is, in fact, an unregulated area, and so the lessors have more freedom of movement, especially the larger lessors, which may not be encumbered with secured financing over the aircraft. So they're not looking over their shoulder at their own lenders. And then, of course, the airline has to look to its equity investors. I look back to a bankruptcy which occurred in the aftermath of the banking crisis 2008, which is Sterling Airways in Denmark. I remember having to fly overnight at short notice to Denmark from Los Angeles, where I was living at the time. And there, Sterling was trying to restructure, trying to avoid going into liquidation. And it was very interesting. Half the people I knew in the industry were there because Sterling had quite a few aircraft on lease from different lessors. We all met in different rooms because for antitrust reasons, we couldn't collude amongst the lessors or amongst the banks. So each of us was put in a separate room. You may be familiar with this procedure, Gautam. And the negotiating team would go from room to room and basically worked through the night, 2 nights running, I think, with us. Lessors, I believe, on one floor and banks on another floor, to achieve different relief from the different creditors. Long story short, both banks and lessors agreed to rent reductions in that case, sufficient to what the airline believed would enable the airline to survive and avoid bankruptcy liquidation. Unfortunately, where they failed at the last hurdle was with their equity investors. In order for their plan to succeed, not only did the lessors have to accept a rent cut, which we all agreed to, not only did the banks have to agree to an interest rate cut, which we all agreed to, but the equity investors would have to put in some fresh equity as well. And there, the shareholders said, well, I'm sorry, but based on this business plan, we don't see that the projected return on our equity investment is sufficient for us, to bear the biggest risk here, to be the equity investors. They even offered, they said, look, we'll put this money up as debt finance if you need it. But of course, what the airline didn't need was more debt. It needed a more equity injection to preserve its debt equity ratios, etc. And so at that last hurdle, I remember the CEO, very nice gentleman from Iceland, he was just exhausted. And he said to us, he said, thank you. He called us all into a room. At that stage, it was the staff. We all have an interest in the company at this point. It was the staff, the lessors, and the banks, not the shareholders, because they had not reached agreement. And he thanked us all for our cooperation, but he had to announce that the equity investors had withdrawn and had left. And as a result, the staff were now basically out of jobs. He would let them know who was being kept on. What was that term you used, Gautam? The management team to see the airline through?
We call it the Asset Preservation Team, or APT.
All right. So we had the equivalent with Sterling Airways, and it was interesting. And now, what had seemed like, meeting all my friends from other leasing companies, a bit like at a family wedding when you meet your cousins again. Now it was like going to a family funeral, unfortunately, in the case of Sterling. And luckily it worked out. Gautam mentioned the problem that lessors have, some desperate airlines or shady airlines, unfortunately, when they're getting into financial difficulty, quite often, not only are they not paying the rent, they can't afford to pay maintenance on the aircraft either. So what they may do is rob parts off your aircraft, if you're a lessor, and put it on another aircraft to keep it in the air longer, and what's called cannibalization of parts. So maybe you have 3 operational aircraft. They can't afford to maintain 3, so they use one as a parts bin for the other 2. And then they reach a point where actually now they have to take the second aircraft out of service and use it to keep 1 aircraft, which is bad news for the owners of the other 2 aircraft, which have been cannibalized. So luckily, this wasn't the case with Sterling Airways, but all of the lessors' engines were on different airframes, which is not unusual for a busy operational airline. We all were able to sort out who had whose engines. We swapped them back. At this point, the Cape Town Convention had not been implemented in Denmark, and the aircraft was registered in Denmark. The airline was based in Denmark, so Cape Town would now apply, but in those days it was pre-Denmark's accession. Under Danish law, it's an interesting point. We were lucky that none of the lessors' engines were on an aircraft, an airframe, that was actually owned by the airline. Because if any of them had, under Danish law, there is accession of title to engines. We often hear the case of the Netherlands raised in this respect, but Denmark is certainly a case, because I had experience with this discussion. If any of the engines of the owner of the aircraft were temporarily installed on an airframe owned by the airline, they then became part of the estate in bankruptcy as a matter of Danish property law. The owner of the engine would, of course, have an unsecured contract claim in bankruptcy, but that's useless. So they don't want to sue as an unsecured creditor. The liquidator, who has a duty to those unsecured creditors to gather in all of the estate of the airline, would have had a duty to assert a property interest over the engine installed on the airline's aircraft. So that would have been a major problem. It wouldn't arise now because the Cape Town Convention provides for separate international interests in engines, so that's fine. It is, however, and Gautam, you touched on this, it's an issue for other installed equipment. So I remember after the Sterling bankruptcy receiving demands from people claiming we installed the in-flight entertainment on the aircraft and we retained ownership under it, under our contract. So, you must give us our in-flight entertainment equipment back. And we said, no, I'm sorry, but once it's installed on our aircraft, as a matter of Danish law and as a matter of the governing law of the contract, English law, these now belong to the owner. You must bring an unsecured claim against the liquidator. So I'm glad none of the engine owners were in the same position as those other avionics equipment owners. Okay, so that's a negotiation that didn't work out. Gautam's, of course, is a case that did work out. What other options are open to an airline? Well, one I mentioned here. Airlines can seek, as part of the negotiations in certain countries, a non-bankruptcy restructuring. English law provides for it, Irish law provides for it, Malaysian law provides for it. Not every country does. It's a system whereby you can seek, without a formal bankruptcy law process, a restructuring which will involve all creditors or all of a class of creditors. There are 3 cases. I don't have time to go into them in detail, so you may be familiar with them. If not, you can look them up if you're interested. MAB Leasing, which was a Malaysian Air case brought in England. Nordic Aviation, which was a case brought in Ireland. And AirAsia, which is a case brought in Malaysia. In each of these cases, the concerns of the lessors were, if a lessor can be bound by a restructuring scheme for a class of creditors where the lessor does not agree to it. I mean, if the lessor agrees, that's fine. There's no problem, as you know, we voluntarily reached in the Sterling case. But can a lessor be bound to go ahead with a restructuring scheme that, say, cuts the rent? In each of those cases, the answer held was, actually, so long as the right of a lessor who does not agree to the restructuring, so long as the right of the lessor under the Cape Town Convention is respected, then there's no problem with everybody else going along with the restructuring scheme. The Cape Town Convention sets out a definition of insolvency proceeding. So you don't look to English law or Irish law or Malaysian law. Under each of those domestic laws, these restructuring proceedings are not bankruptcy proceedings. But for the Cape Town Convention, we don't care about the local applicable law for this purpose. We look at the definition as used in the convention. And it defines insolvency proceeding as a bankruptcy, liquidation, or other collective judicial or administrative proceeding. So bankruptcy or other proceeding. So we look at the other limb, in which the assets and affairs of the debtor are subject to control or supervision by the court for the purposes of reorganization or liquidation. So it could be a non-bankruptcy proceeding, which is for the purpose of reorganization. That comes within the definition of insolvency proceeding under the Cape Town Convention. And so long as, therefore, any lessor who does not agree to the restructuring terms is free to take repossession of the aircraft in accordance with Alternative A or Alternative B of the Aircraft Protocol to the Cape Town Convention, the terms of the convention are met. So basically, long story short, if you do not agree to this restructuring, you can demand your aircraft back within the relevant fixed period of time under the convention, as adopted by the country where the airline is based. What is meant by return of the aircraft? Well, the VB Leaseco case in Australia, that's the involving Virgin Australia, determined that that simply means where the aircraft protocol says that the liquidator or the administrator will give possession of the aircraft, it literally means just make it available. They simply have to say, it's on the tarmac here, come pick it up. They don't have to put the aircraft back in redelivery condition first. They don't have to clear any liens that may be on the aircraft. That's not their obligation under this section of the Cape Town Convention. Now, let's say the airline's country does not have this non-bankruptcy restructuring proceeding. Maybe you can still bring a case under the English Companies Act of 2006, Part 26, which provides for non-bankruptcy restructuring, so long as there's a sufficient connection with England. The English courts have held there is a sufficient connection with England if the creditor's contract is governed by English law. So if your lease is governed by English law and you're an airline, even if your own law doesn't enable you to do this domestically, you may be able to get into the English courts. Again, bear that in mind if you're in this situation. Well, let's say all of this has failed, or you never got in touch and communicated with your lessor in the first place. The lessor will probably try to seek arrest of your aircraft, as happened in the Netherlands for Jet Airways. The three conventions, I don't really have time to go through in detail, but Rome Convention of 1933 doesn't apply in many countries, but it still applies, I believe, in Germany and a few European countries. Interestingly, this protects an airline. It prevents the arrest of an aircraft in what's called a regular line of service. I don't know what that means. Scheduled flights? Who knows? It's never been litigated. You can't arrest an aircraft when it's basically in service. So if the passengers are boarding the flight, getting ready to go, you can't do that. Geneva Convention of 1948 provides for recognition of your rights in an aircraft, including your rights to repossess it in accordance with your contract. And the Cape Town Convention specifically sets out ability to seek an ex parte arrest of an aircraft. When you seek an ex parte arrest of an aircraft, you may have to post a bond. This can be very expensive. It depends on the local court rules. Many years ago, when I arrested a Brazilian aircraft on behalf of the lessor in Toronto, Pearson Airport in Toronto, we chose Toronto because the judge there agreed not to impose a bond at all. I think he was too generous in our favor. The idea is that because it's an ex parte order and the airline is not there to defend itself, one you have a duty to disclose all facts, including those unfavorable to your case. And 2, post such bond as may be determined by the judge or is required by the court rules. Sometimes the court rules are twice the value of the aircraft. In the case of Toronto, we were seeking the arrest of 4 wide-body MD-11 aircraft. So each one was worth about $200 million. It would have been $1 billion in bonds to post. So we didn't go in those courts. We went with Toronto. And this arrest order is really intended to freeze the aircraft while substantive debt proceedings are being pursued in the courts where set out in the lease contract, whether it's New York or English law. Gautam has mentioned use of the IDIRA. Again, this is a sui generis replacement, if you like, to the deregistration power of attorney under the Cape Town Convention. The main reason it was brought in is because it is set out in a form dealt with under the convention. It's not bound by national laws, which quite often in civil law countries provide that as deregistration power of attorney is always revocable, even if it is stated to be irrevocable. And so an aviation authority would say, well, I know you have this power of attorney, but I've no means of knowing that the airline hasn't revoked it. With the IDIRA, there's no issue about that. So long as you follow the wording set out in the convention, so it's not negotiable, you can enforce it. I arrested some aircraft in Russia, some within the last few years. And there the aircraft were not registered in Russia. They were registered in Ireland under Article 83 bis of the Chicago Convention because of perceived difficulties in the past of deregistering aircraft in a hostile repossession from the Russian register. But Russia had now adopted the Cape Town Convention. They're trying to insist that people accept registration in Russia now. I don't think they've been successful yet. But the IDIRA covers export as well as deregistration. And I have to say that the Russian authorities cooperated very well in accepting the IDIRA for the purposes of export. I'll just have time to touch on Kingfisher Airways, which Gautam mentioned. It is true, certainly the leasing company I was working for at the time, based on our difficulty in with customs and deregistration and generally in India at the time, for many years afterwards, our marketing staff did not even dare to present a potential deal in India to our CEO, who would fly into a rage if India was mentioned. He said, no, that's, I will never do business there again. Well, you never say never, of course. And things have changed an awful lot in India since then. But I'll finish on with these 3 links here. Jurisdictional risk is a huge issue for lessors and financiers nowadays. Of course, they share information casually, but also through the Cape Town Academic Project. They had their Cape Town Convention seminar earlier this week, which was very interesting and touched on some of the points we're touching on. They actually gather information on compliance with the Cape Town Convention, and they help feed that information then into the Aviation Working Group, which represents basically the leasing companies and the banks, who have produced a Cape Town Convention compliance index. This index is now used by rating agencies when they're considering not the credit risk of the airline, but the jurisdictional risk. This is very persuasive amongst rating agencies now, and so has a direct impact on the cost of raising funds to airlines. And more generally, not just Cape Town, but generally on the difficulties of repossession or ease of repossession in a country. There's also the freely available Pillsbury World Aircraft Repossession Index, which again, I'd recommend to you, and it is a fascinating read. So that's my presentation. So thank you all for your attention, and back to you, Maria.
Thank you, Donal. Thank you both very much for these really engaging presentations. Before we move on to our Q&A session, however, I would like to ask Gautam if, Gautam, do you have any comments or Donal's presentation, or if you would like to add anything, please go ahead.
Sure, thank you, Maria. Thanks, Donal. That was very informative for me as well. There is one slide I omitted in my enthusiasm to press the page down button. So if you don't mind, I'll just share that with all of you and walk you through it. So give me 3 minutes. Thank you. So ladies and gentlemen, a lot of you may wonder, other than just helping the resolution professional with, packaging the airline and offering it to resolution applicants, what else kept me and my team busy over the last 2 years? Aircraft-wise, of course. One, of course, and a lot of this was thanks to COVID. So you see, the government of India, when COVID struck in March of 2020, locked the airspace down for international flights. We realized that India has a very significant diaspora in different parts of the world who wanted to come back to India. Either they had gone there on holiday or they were there on business, students, people who needed to come back to old parents who required medical attention. So the government invited Indian Airlines to operate repatriation flights, and these were called Vande Bharat flights. Bharat is the Indian name for India. We threw our hat in the ring saying that, look, we have 6 777s in our fleet. We have qualified pilots. While our operating certificate or operating permit has been suspended, would you consider giving us a one-time approval or a dispensation, if you'd like to call it that, for us to operate these flights to help the government ferry Indians back to the country? Unfortunately, we did not get the approvals. The same was the story for the cargo flights that the government wanted people to, Indian Airlines to operate, because obviously there were no passengers who were flying. We also engaged in the sale of inventory and assets. So for those of you who haven't worked in an airline, there are consumables, rotables, and spare parts. And consumables have a specific shelf life. And if you don't get rid of them, if you don't use them or dispose them before those dates, they are of no use. So the RP, the resolution professional, also embarked on that exercise to try and get rid of inventory or sell inventory, bring in money or liquidity into the company to run its operations at that point in time. And of course, this was done with the consent of the Committee of Creditors. So the banks had to approve this before we went out and did it. 2 very significant transactions that we did was our 777 aircraft were on finance lease with US Exim guarantees, and they had a small amount of payment left before title would transfer to us. One of these was, of course, also the Amsterdam that was stuck in the aircraft that was stuck in Amsterdam. So we managed to close the financing by paying the last stub payment to the lenders on the US Exim guaranteed aircraft, and we took title to 6 Boeing 777s. We have 3 Airbus A330s, as I mentioned earlier. The financing on that has also been completed, and we are working with the European export credit agencies as we speak to try and get the title to those aircraft transferred to us. One of the aircraft, as you will recollect, I said was on sublease outside the country. That's our only airworthy aircraft at this point in time. The sublease expired in May 2021, and we are working with Air Serbia and Etihad to have that aircraft returned to us. Another job, of course, and Donal mentioned this when he was talking about his experiences in Denmark, was about normalizing engines and APUs. What this essentially means is that if the aircraft or the airframe, does not have its original engines fitted to it and it's sitting on someone else's airframe, you need to normalize it to ensure that the aircraft, which is basically the airframe and its 2 engines or 4 engines if it's a 340 or a A380, and that's thankfully not the case with us, you need to ensure that they are all in one place for a lessor to repossess the aircraft or to be able to ferry the aircraft out. So there was a lot of normalizing engines and APUs, that's the auxiliary power units, which were seated on or housed on aircraft that were not necessarily its mothership. And of course, apart from all this, there was a lot of troubleshooting, firefighting, things that we had never done before. And I ended up, looking after departments that I earlier had only nodding acquaintance with. So, Maria, I've said what I had to. Over to you, and we can take any questions they may have. Thank you.
Okay, perfect. Thank you very much. So let's see what our audience is curious to know more about. We have quite a few questions. I'll try to go through most of them. So the first question is for both our speakers. What are the financial and operational considerations from the lessors to accept the lease restructuring? Will the state-owned carrier be favorable towards these schemes? Are there any other forms of lease restructuring? And this question is being asked in the light of the Lion Air and Garuda from Indonesia having been rejected by the lessors to use these schemes. Up to you.
Okay, well, maybe if I can try first. The question is so broad, to be honest, it's hard to know where to begin to answer it. Each case is unique, as I mentioned. And so certainly the fact that, say, with in the case of Garuda, as a flag carrier, as long as the lessors think that that will remain, I think they would be quite motivated to try and reach a deal with it. On the other hand, it depends who the lessors are. As I said, don't forget that the lessors, if they themselves are leveraged, they can't afford to put their own financial position at risk in terms of, you know, what relief they may be able to offer. And the other point is, again, I don't know the specifics of those cases that are being mentioned, but the lessor will always be balancing this against, well, if this doesn't work out, if the terms aren't acceptable to me, what else can I do with the aircraft? And so it may well be that depending on the aircraft type, the lessor has figured out that even if it's at a lower rent than under the original contract, if they can place the aircraft elsewhere now at a higher rent than the airline seeking the restructuring is willing to pay, it may well be in the lessor's interest to take those aircraft back. So it's really hard to generalize. It's so case specific.
Okay, thank you. Gautam?
On that point, so speaking of the experience of how lessors have dealt with Air India, which is the national carrier in India. So typically the government does step in to help, and either they've given a sovereign guarantee or the Indian government, you know, has ways and means of engaging with the lessor to give them the comfort. But as far as private carriers are concerned, I think they don't have too much elbow room in these restructurings. It is down to a commercial discussion and you have to agree on something. Otherwise, I think the lessor will precipitate steps against you, legal or otherwise, as we have seen. So.
All right, thank you both very much. Let's move on to the second question, which is a question for Gautam. It's actually a very interesting question. How was the reaction of the Indian travel agency associations when they learned that ticket refunds could not be admitted? And a follow-up question, is there any chance of further payments to passengers if the airline is ever restored?
I would guess this question is coming from someone who has a ticket on Jet which has not been refunded. Well, the travel agents obviously were very upset when Jet went under, and obviously there was no scope of them recovering anything. We did receive myriad queries from the various travel agents who sold tickets in the market on Jet. The only advice we had to them was to file their claims, and the claims would be tabulated, and it would then be for the resolution applicant or the successful bidder to decide in the payout or in the settlement that they were arranging what would come to the travel agent or the traveling public. Unfortunately, there isn't very much on offer. In fact, there is nothing for them. In the 4 iterations we've had with the various bidders starting 2019, we tried telling them that, look, we had almost 5,000 ticket claims that have come through. Why don't you offer, say, a 10% discount voucher or something like that to all the people whose tickets could not be refunded and who've lost money on Jet? The suggestion was taken on board by some of these resolution applicants, but unfortunately, the one that has met the court approval, there is no such relief for the traveling public. So I'm sorry for that. Thank you.
All right. Thank you, Gautam, very much. And the next question for Dr. Hanley. When airlines are faced, this is actually a legal question. When airlines are faced with a new lessor for an aircraft, are the previous clauses still in application, or is the new lessor free to change conditions? And if the latter is true, how do we guarantee previsibility for the airline?
In a typically drafted lease, the rights of the lessor to novate the lease to a new lessor who would buy the aircraft and take over the lease must respect the rights of the airline. So typically it'll use words along the lines of the lessee shall not incur greater obligations or enjoy fewer rights than it did under the original lease. So from that point of view, strictly speaking, there really shouldn't be any impact. Where an airline needs to pay attention is maybe not legally as such, but in terms of, as I said, the nature of the new lessor. Qualitatively, it could be, there's really, frankly, nothing that airlines can practically do to stop this. But again, if the new lessor is simply a managed fund, there may not be much of a relationship there. Even if there's a relationship with the manager is purely a manager and doesn't have the same rights really to make discretionary calls that that an actual substantive owner would have. So the other point to bear in mind here is that if the new lessor is based in a different jurisdiction from the old lessor, of course, the airline will need to make sure, and has the right to make sure, that this wouldn't involve any adverse tax consequences in terms of withholding tax, etc., being imposed because of the different jurisdiction. So in principle, the rights are always protected, but the airline will have to, generally speaking, would be advised to hire outside counsel to review the lease novation agreement to ensure this, and would charge its lessor for the legal fees of hiring that outside counsel, because the airline shouldn't have to incur any cost. I hope that helps.
So Maria, I'd just like to give an airline perspective
Go
on
ahead.
this.
Yeah, of course.
Thank you. So from Jet Airways' standpoint, and probably some other Indian airlines, I'm not sure, but speaking for Jet, we never did any aircraft lease novations when lessors sought to trade in aircraft and pass it on to other lessors. So what ended up happening in those cases is that we took the existing lease agreement, and it was the very same existing lease agreement that got replicated with the new lessor. And there was a termination with the existing or the old lessor. And of course, there were the standard clauses that Donal mentioned, that the airline should not be any worse off than what it was as per the original lease when it entered into the agreement, into the lease agreement with the new lessor. There are certain conditions that that India has. For instance, given its relations with Pakistan, you couldn't have a Pakistani fund or someone like that behind that new lessor. So there were certain credentials that the new lessor needed to satisfy. And we would be very upfront with our lessors when they said, look, you know, we've leased this aircraft to you, but the portfolio has been sold to XYZ. We said, that's fine. I know that's part of your business. You probably want to, you know, bring in newer aircraft, and that lessor wants a foot in the door with Jet Airways or whatever. Please make sure that, you know, it's an Irish lessor. It's not a fund controlled by a country that India or the Indian laws do not recognize. And that's the way we went about it. But largely, we stuck to the old clauses that we had in the agreement, barring a few here and there, which may have changed because of change in law. I hope that helps.
Thank you, Gautam. So, Gautam, in the case of Jet Airways and Indian bankruptcy law, is the new Jet Airways a new legal entity which has acquired the assets from the old company, or is the new Jet Airways the same corporation but just released from all former debt?
The latter.
The latter? All right. Would you like to tell us more, or should I move on to the next question?
That's as much as I'm permitted to say.
All right. Thank you. So one more question for you. With respect to the Jet Airways bankruptcy case, is the Insolvency and Bankruptcy Code in India, as well as the bankruptcy law in the Netherlands, compliant with Cape Town Convention, and does that have an impact on secured creditors when undertaking aviation financing or leasing?
So my response to this is that the Insolvency and Bankruptcy Code, when it was enacted in 2016, didn't really, you know, have an eye out on the Cape Town Convention and what the conditions of the Cape Town Convention are, with specific reference to an airline insolvency, because you have only a dozen or so airlines in India, and the formulators of the Insolvency and Bankruptcy Code obviously did not have it within their remit to look at industry-specific regulations to kind of build into the Insolvency and Bankruptcy Code. Having said that, now that the Indian system has seen an airline insolvency, And in the last 2 years, the Insolvency and Bankruptcy Code has been undergoing changes as and when insolvencies are handled by the various resolution professionals and the courts. So it is reasonable to expect that airline insolvencies, particularly with reference to Cape Town, will find some kind of mention in subsequent iterations of the Insolvency and Bankruptcy Code. As far as the Dutch insolvency is concerned, I'm sorry, I'm not qualified to answer that. So I'm guessing that they will be mindful of the provisions of this of the Cape Town Convention, but that's as much as I can say.
All right, Donal, would you like to add something?
I have nothing further from you, I think, on that.
All right. So the next question is for you, Donal, and our audience would like to know, under Article 3 of the Cape Town Convention, accompanied by the protocol, a seller is a debtor. So can the seller claim anything under the Cape Town Convention? Why not? Under which other articles? And whether Article 3 would be the only legal basis, and whether there would be other legal bases that could come into play. And this is asked from the perspective of non-CTC claims versus CTC claims, Cape Town Convention, non-Cape Town Convention.
Okay, to be honest, I'm afraid I don't understand the question, because if I understand, you say what claims are open to a seller, but in what circumstances?
If the person who asked the question would like to clarify more, please write me to the chat, and I will move on to our next and last question, because I think we're running out of time. And this question is for Gautam. Gautam, would you like to give a further explanation regarding the new Indian laws on insolvency? Do you think, I mean, in your opinion, were they a response to the growth of such businesses as aircraft leasing?
I think the answer to that question is an entire webinar in itself. I'm afraid I can't answer that very precisely. So whoever's asked the question is free to reach out to me one-on-one, and I'd be happy to engage in a conversation with them.
Perfect. Thank you very much. Donal, Gautam, would you have any questions for each other?
Nothing from my side. I think Donal's been exceedingly clear as far as I'm concerned, because having sat at the other side of the table, it's been very interesting and fascinating to know how Donal has viewed it from his side of the table as a lessor.
And well, likewise for me, Gautam, it's also very interesting, to get the airline's perspective. What is fascinating about this business is, we're all in aviation because we enjoy the industry, and there have been worries that maybe Zoom and as we are using now will replace it. But I've found, and I don't know, Gautam, if you found the same thing, that the dynamics of sitting around a table together are quite remarkable, because whilst the airline lessee and the lessor will both protect their respective interests and do their duty correctly, they still effectively form a team who've been tasked with finding a resolution if at all possible. And so that team, although reporting back to their respective bosses, really don't want to have to report back a failure. There is a certain dynamic to getting around a table with somebody. Also, because unlike, say, on a Zoom call, you can do sort of sidebars. When somebody goes out to get a glass of water, occasionally you can step out with them and say, look, what's really going on here? What's your constraint that is stopping you from agreeing this? And people can speak a little more freely, a little more unofficially. And it's not even to underplay the importance of soft things like going for dinner afterwards, even after a difficult day of negotiation, where you see a little bit of the human side of the people. In a way, it helps to maximize the chances that if a mutually acceptable deal can be found, that it will be found. Of course, it doesn't always guarantee it. I remember one case when I was working with a leasing company where we had to arrest 2 aircraft in Hong Kong from an Asian carrier. And the CEO was very upset. Well, he wasn't too upset. He was upset when we arrested the first aircraft. When we arrested the second aircraft, that was the only other aircraft in his fleet that was suitable for international operations. And he said, I didn't think you had 2 arrest orders. And I said, well, obviously I was going to get one for each of the 2 aircraft we had with you. So I would have thought it was obvious. But I explained to him, I said, look, this is why I flew to your country and explained to you that if we weren't able to reach agreement, I told you what our next steps would be. And they're exactly what we did. And he said he understood it. And so actually, to make it up to him, we had an airline customer event every year. And we invited him to come to it. And he actually came. And, he took part in our customer event, even though he wasn't technically a customer at that stage. So, we maintained a working relationship with him. So anyway, that's all I have by way of explanation on the importance of face-to-face negotiation.
I entirely agree with what you've said, Donal. And we are seeing the effect of this in India, because domestic travel is almost back to 80% of pre-COVID levels. People are itching to travel, not just for leisure, but also for business meetings, because there is only so much one can do on a Zoom call or a MS Teams call. And also, given the fact that our population is so large, Indians, and this is my personal view, Indians really aren't suited to working from home because their homes are not as large as, say, a European or a North American home is. Most people are living in a 1-bedroom house. If the wife is on a call, the child is on a school call, there really is no place left for the other member of the household to get on another work call. And we are seeing this. And in fact, just last week, I personally had to travel to Delhi to meet a few folks on work. And it could have been done on Zoom, but I think everyone was very welcome of the prospect of meeting in person, walking through an airport. Of course, there aren't as many people there now as there used to be in the heyday. But my sense is that, and we are coming into our big festive season here in India next month, Diwali, the Festival of Lights. We'll see a lot of people traveling at that time, visiting friends and relatives, because distances are large. North to south is almost 3,000 kilometers. East to west is another 2,500. Any other mode of transport is not so effective in India. It's very time consuming, and air travel is the only option. So I see that Indian domestic market, Indian domestic flying is going to bounce back very, very quickly. And I think our industry is going to see a reversal of its fortunes for the better. Thank you, Maria.
All right, thank you both very much. And I'd like to close the Q&A session with the last question. I'm actually curious to know, both of you mentioned how important it is that airlines are in contact with the banks, with the creditors, and they speak with them. So based on your own experiences, I'm curious to know how much of a leverage an airline would have in motivating the bank to work with them, and to what extent would you say that banks cooperate, and why?
Donal, would you like to go first?
Again, I think the banks will start out from the point of view of trying to be as helpful as they can. But I, again, remind you that the banks are regulated, unlike the lessors. And so their freedom for movement may be narrower. But certainly the importance of maintaining good relationship with your banks can't be understated. What I would suggest to airlines is that's something you need to be doing with your banks before you get into trouble, to maintain the good relationship long before you get to that point. But of course, the banks won't be able to do work magic, to do things that are impossible. They have their duties ultimately. But certainly, it's bad news for a bank when it has to repossess an aircraft, because there's a lot of expense and uncertainty involved in it as well. So it, generally speaking, is a last resort for a financier or for a lessor.
Speaking from an airline's perspective, having been through an insolvency, earlier when we talk to the banks, we talk about our financial health and the SUCOR that we expected from them. While the banks were understanding and supportive, a lot of them were, look, if it ain't totally broke, we don't need to fix it. But I think now that thinking is going to change in the Indian banking sector, where when airlines or any distressed company comes to the bank and says, look, we need to talk about the loan that we have or the additional funds that we require, I think banks are going to sit up and take note of it and be a little more receptive and proactive to try and avert an insolvency, which wasn't necessarily the case earlier. But yes, banks did give us an audience, banks did talk to us, banks did listen to us, but unfortunately there was no action forthcoming from it. But I'm of the firm belief that that's going to change, particularly for the aviation sector in India going forward.
Thank you very much, Donal and Gautam. Professor Jakhu, would you like, do you have any questions? Would you like to add something?
Oh, thank you very much. I cannot express my gratitude enough to excellent presentations. I think we have a very good view of both sides, lessor and lessee, in that, and our panelists shared very generously their personal experience and knowledge of the food. It's very informative and educational in the sense. And I can say a large majority of our attendees stayed with us till the end. So that shows the webinar has been very, very successful. And the suggestions and made by both the panelists from their personal experience are very important in crisis situation. And I think the level of crisis is, as it's very clear in this situation, is the life and death of an airline, and a number of ways the lives of thousands, if not millions of people involved in the industry. You know, what happened, the airline goes, thousands of people are, you know, laid off, and the life of their children and all kind of thing this is a very serious matter. And I think the perspective we got it from both of them is really, really useful. I see that there are a lot of lessons which all learn, particularly the last one which Gautam mentioned, after this situation in India. Positive development is the efforts on the part of banks to avert insolvencies. I think that this is lessons learned with that. And I also see that I think, which I generally believe very closely, the personal relations cannot be replaced by the most efficient means of communication. That means there is a hope, and actually fairly good hope, for aviation industry. People need to travel not only for leisure but also for business. I think that's very, very good. I think the close, perhaps the most important lesson or the message which I think which is expressed by our panelists is the open communications, open sort of cooperation between the parties, all stakeholders, because everybody at the end will lose. So open conversations, communications, personal relationship, and that kind of thing, and not considering the other person to be an enemy or adversary. So I think that is a single most lesson which I think can be learned from this. In the case of Donal has a very good view of the comparative analysis, different perspective, different airlines, and I think they're very useful. But I think the Gautam's perspective, which I think it's good to see the challenge posed to jet airways of economic, of course, no doubt, but then is the legal challenge, the introduction of the new law, insolvency law, the people involved in the application of law were not very familiar. And on top of that, accession to or ratification of Cape Town conventions, one after another, all kind of thing. But I think which my impression or my conclusion is that all these problems are serious, very serious. But I also see smart persons or smart personnel can come up with the smart solutions. And that is what I see from both the panelists, which the smart personnel involved and dedication. And it's good to see Gautam continue with Jet Airways, artery medicine. I think that is what I mentioned up front in my opening statement. You know, it's good to see competent people having some kind of loyalty to institutions, and that I personally believe in my own personal life. And who are these smart people? Again, sort of my view, which I always believe, but is confirmed by the presentation. People who have a broad ideas, thinking, broad knowledge, rather than narrow knowledge. People involved in this business have a fairly good legal background, both at national level, international level, and also, I will say, the knowledge of foreign law. I think the legal matters is about, and a very good knowledge, experience in airline business, and at the same time, good knowledge about the banking operations. They are interested in that, and also technical, saying what happens to aircraft. And I was very impressed by the point Gautam made, which was, I think, generally not explained or expressed. The understanding of the local conditions, how you maintain, how you keep the aircrafts in different parts of the world. Part of India, and what steps you have to take on those kind of things, which, generalized information may not be, conditions in India, and he explained very well, the weather condition in India, local, roads conditions in India are very different from and even I will say to the level of housing in India. I mean, local conditions, constraints are very, very important. And I, again, but the last word I will say, I really salute to our panelists and thank them profoundly for sharing their knowledge and the time with us. Again, thank you both. I will be not doing my proper duty if I don't express my profound thanks to Maria, doing an excellent job moderating the session, and I will say. And it has been a very good, very good experience. And I think our inaugural webinar is success, at least in my view. And you see, I said that, and of course, there was no point holding this webinar if you do not have audience people. And I'm very happy a large majority of stayed with us till the end. And again, thank you very much to all the people who joined us in this webinar. What we will be, we will encourage everybody to write to us, to send us your comments, and both positive and negative about the webinar. So we learn from our experience. That is, we will be keeping in touch with you. You should be in touch with us with respect to the other episodes. Again, thank you very much. Generally, we used to say have a safe flight. But I will say have a safe time with your families and friends. Thank you all. Great work. Thank you. Thank you very much.
Thank you, Professor Jakhu, and thank you very much, Gautam and Donal, for walking us through what the financial difficulties of airlines look like and what is being done about them. We hope to have you again with us in the future, hopefully in person. At this point, I'd just like to do some organizational announcements. We are recording this session. We will make it available to you via email as well. We'll send you the link like Professor Jakhu mentioned. But if you do have more questions, we had to cut short our Q&A session. If you do have more questions, don't hesitate to reach out to our experts. We will share their emails with you very soon. So thank you again to the speakers, to the audience, to Kiran as well. Our next episode will focus on aviation safety, and we hope to see you all there. Professor Jakhu, a final word. Goodbye from me and see you soon. Professor Jakhu, please close this session.
Thank you very much, and I declare the webinar closed. Thank you.
Thank you. See you soon.